Hey, this is Eric Durack, and welcome to MedHealth Fit, the TV show that integrates wellness and healthcare. And tonight we will be talking again about the national vaccine issue. And I am happy to have on the show again Travis Middleton, my friend, my colleague, who for the past couple years has been working with me on all issues related to vaccine. Welcome to the show, Travis.
Thanks, glad to be back.
Well, Travis, you are a legal researcher, and I think that you are one of the great minds of legal research in terms of the vaccine issue. You're a paralegal. You are also author of the 2016 Federal RICO Law Suit against Senator Pan, California State Legislature, and Governor Jerry Brown. So you and I did a show last year on the elements of a RICO lawsuit, and that episode is on my YouTube channel, MedHealth Fit, and it has received thousands of views. There are a lot of people around the country who are interested in your brand of justice versus class action lawsuits and all of these other types of things. So we're going to follow up today with our original interview from last year, and we're going to discuss some other types of issues in a little bit more detail. So the first question that I want to ask you is, what is the status right now of Senate Bill 277 RICO suit? From some of the original roadblocks, and why is this case different than some of the other cases that have been there? So go ahead.
I remember last year giving you a PowerPoint prezo on the elements of a racketeering Hobbs Act case, and I remember telling you on that podcast that that my journey and my obstacles would be dealing with the judge, not the attorneys. I can beat any attorney any day, given a level playing field. It's the judge I have to do battle with 90% of the time. So that being said, and I said also, but the judge has to be careful when they deal with a racketeering case, because it's like a vacuum. If a judge or an attorney decides they're going to try to disrupt the process or game the system to derail that case, they too can become defendants of the co-conspirator in a racketeering case, which is just what came to pass in our case this time. And so the status of the case is now.
Well, let me ask. So that roadblock, the judge basically tried to dismiss the case or not handle the case. From what I remember, that case dragged on for a very long time with no adjudication on it whatsoever. And then you actually came back and you said to the judge, either do this or I'm going to have you as a kind of a co-conspirator. Am I correct?
Well, not exactly. Well, what had occurred in December 13th last year, we had a 12B6 motion to dismiss hearing.
Okay.
Now, for the attorneys listening, the ones who do civil practice in federal court, a 12B6 hearing and a motion to dismiss is based upon either you are suing the wrong defendants, or your complaint is deficient in that you didn't state a claim upon which relief can be granted, either technically or somewhere in the pleading style. I'm way beyond that process of doing that right. I've done it too many times.
Right.
So for me, I understand there is a Supreme Court standard when the courts deal with a pro se or a non-lawyer in federal court, called the Kerner-Haynes Doctrine, a case where a non-lawyer got his case to the Supreme Court on the premise that the Supreme Court set a standard that you have to be lenient with a non-lawyer because they don't have the training that attorneys do. So the courts are required to show non-lawyers some latitude in their pleading style and sufficiency of the defects, and at least show them where the defects are, not teach them, but show them where they are and give them an opportunity to cure the defects before the case gets dismissed.
Right.
Now, I'm beyond that. My case wasn't deficient in any respect. So in this 12B6 hearing, what they were trying to make the claim was, well, Mr. Middleton, you're suing the wrong people. So the magistrate judge said to me, well, sir, I can't give you any legal advice, but we do have a pro se clinic down the hall that you might want to avail yourself to learn about the difference between a criminal RICO and a civil RICO.
Which you already know.
I already know that, though.
Right.
So she was placating me. I was a little offended by that, but nonetheless, what she was trying to do is figure out a way on the record to justify adopting the opposing attorney's argument that we were suing the wrong defendants because they had absolute judicial, what's called legislative immunity. And they do not in this case. They have a lot of immunity in certain circumstances.
Exactly, and this is for what you have explained to me and others many times before. Many people in the judicial realm, judges, attorneys, attorney assistants, whatever, they say, well, you can't file a suit against us because of this immunity. Same with what we're trying to deal with Senator Pan.
Correct.
He's basically saying, I am California state legislature, so just by virtue of holding this office, almost like what we heard with President Trump,
Right.
Donald Trump today says, well, I'm the president, so therefore I can't commit a crime. Well, you can.
Right.
And these arguments are weak. So what you did is you said, based on federal racketeering statutes, this is not correct. So explain that.
Right. Well, based on common law, it's not correct. Okay. Under common law, they have a lot of immunities under the 11th Amendment. It's like we get our laws from Roman civil law, the biblical law from King James Bible or the Mosaic Code, and from English common law.
Right.
Okay. So one of the pillars of our country's laws is the Mosaic Code and common law. Okay. So when they swore an oath of office to uphold the supreme law of the land, that goes back to the biblical text of oath and swearing. That's been codified. Now,
Okay, go ahead.
But what happens is, when they do other than honor their oath in their official duties in their office, that's what's known as treason. And there's
could it be also known as breach of contract or breach of oath?
Yes.
Treason is a big word in
yes,
the
but
U.S. government.
Yes, it is. But when they violate the oath of office to the Supremacy Clause, it connotates treason. It triggers what's called a perjury of their oath and a breach of the contract with the public.
Okay, so breach and perjury sound a little bit more, we can go after those.
So that's under the common law rule. Now, there's a remedy for that when they do that and get caught doing that. They can be impeached, obviously. They can be ousted by a quo warranto or a process like that. Or the citizens can file suit as well in a way to get them out of office or deal with their breach of oath of office, like what we're doing. Now, under the Hobbs Act modality, it's called what they were doing in Sacramento when they were finagling the process of getting enough votes for SB 277 without letting it take its natural course. That was an obstruction charge. Now, obstruction charges usually go or are triggered when you're involved in a judicial process or a quasi-judicial process, an administrative hearing, something of that nature. Well, I can't think of any more definitive process judicially than a legislature making law in the Capitol.
Right. And for the audience right now, let me sort of take people back. Is that during this process of trying to ratify Senate Bill 277 in the California State Legislature, the head legislative person said to Senator Pan, as he was talking to some folks from the pharmaceutical industry, they said, well, you may want to table this vote until next week, because she knew that he did not have the majority of votes
Correct.
at that time. So they tabled it when there were hundreds of anti SB 277 people in the audience who were mortified that this happened. Came back a week later, had the votes, passed it, no problem. So we saw, for a lot of people who had not seen the legislative process at that time, saw what they saw. It was a huge obstruction of their justice, because here he is, he's colluding with people. Right there on camera, pharmaceutical company, they make a decision, the next week they hold a vote, and he has the recommended vote.
Right. Now, that process, how they did that, they breached the oath of offices.
Right.
Their oath dictates they do everything constitutionally first. That's not constitutional.
Absolutely. Collusion never is, anyway.
All right. So, in this December 13th hearing, the magistrate judge wanted to create a narrative on the record to support the opposing attorney's argument that they can't be sued because they enjoy absolute legislative immunity. But she never addressed the issue of the breach of oath of office. Right. And she recommended that the case be dismissed without prejudice. Now, what that means technically is the case isn't over. She admitted that we have to dismiss those legislative defendants, file a new action, pay a new filing fee, serve summonses all over again, and come back to the table with a fresh complaint. I'm not going to do that. Now, if the complaint was deficient, in any respect, rather than dismissing the case, which is what she wasn't doing, she was actually, without prejudice, mean leave. So what she should have ruled was, we'll grant you leave to amend, Mr. Middleton, which means go reshape the pleading since you're already here, bring in new defendants. We'll get you new summons to go out and serve new defendants without paying another filing fee, without a whole new action, a new case number. Leave to amend.
Right.
No, dismiss without prejudice means file a new action.
That's
obstructing justice because she doesn't have a valid reason for doing that.
Right.
And so I made her a defendant in the second amendment complaint. And I'll tell you how that worked out. So I was supposed to follow the magistrate's recommendation and dismiss this case without prejudice and file for new defendants. Well, I said to you, some other people back then, I'm not going to do that. Okay, I'm going to make her a defendant as a co-conspirator with the opposing attorneys for what they were doing with her against us.
Right.
Well, the clerk of the court told me that he couldn't take the pleading as it is because it defied the magistrate's recommendation. The judge has to okay it first. But what we can do is we can have it filed as submitted. You can't get a summons for it yet because the judge hasn't okayed it per the magistrate's recommendation. And the judge is okay. I said, I understand that. I said, let's just file it. Now, I had it filed on January the 9th of this year. So when he sees it, I'm thinking he's either going to strike it from the record because it defies the magistrate's order and recommendation. I have to start all over again and go do what she said do. No, the problem they have, neither of them read the complaint. So when he bring his ruling down back in the 1st of August, he made a ruling, the second amendment complaint is now the operative complaint, and all defendants must file a response in 30 days. And the plaintiff must file a reply 14 days after that. Well, he didn't read the complaint because his own magistrate judge was a co-conspirator and defendant, as well as the Attorney General's office and the Office of Legislative Counsel was also defendants. And so, but they filed their reply, we're immune, and they're not.
Right.
But the magistrate judge didn't file a reply, so I placed her in default. So recently, I got a response from the district court judge, Mr. Wilson, that stated that he wanted me and only me to file a response as to why the magistrate judge should not be dismissed due to her judicial immunity. So it took me 1 day to do this response. I had 6 days to get it done by his order. And to summarize it for you, I had basically stated that this officer obstructed justice in violation of her oath to the Supremacy Clause of the U.S. Constitution, which states that all judicial officers and legislators must honor this oath of office. And I also stated behind that this part of the U.S. Constitution is lawfully enacted by Congress. It is constitutional and is obligated to be followed by the defendants. Further, no defendant in this case or the court has offered any evidence or any pleadings to the contrary to this statement.
Okay, and that's a big point.
Yes.
If they're going to debate you on this and say, well, we need it dismissed, they have to have some reason to do that. And that's just like, we're immune because you are an expert. You have an expertise in racketeering cases. This is your second, third, or fourth case, but enough that you
I've
know
done
what
more
you're
than
doing.
4 racketeering cases, but I wouldn't call myself an expert.
You have an expertise.
Yes.
Right. I have an expertise in a number of things. Like in vaccines, I don't call myself an expert. Right. I'm not a medical doctor. There are certain things. I'm not an immunologist, but I have, like you, over 20 years experience in the vaccine issue from the vaccine freedom element. So they're trying to use this very flimsy, we're immune, and you've already gone and chipped away at that. So I want to belabor the first question here, but as of this date, the RICO case is still going.
And the reason why it is, I also filed a writ of mandamus at the Ninth Circuit Court of Appeals to intervene to what the district court is doing down here at this level, at the trial court level. They are refusing to adjudicate our issue of the breach of oath of office. At the same time, they're skipping around the other issues of the pleading as well and saying, well, you're saying briberies are illegal and they can't be committing bribery because they're immune from that. And I have case law that says they can be immune from a bribery charge, even though it's not protected official conduct.
Right.
Fine. I'm not worried about the bribery.
So a state legislator can be bribed and they can't go to jail for it, but anyone else can.
True. Case law says that in the Ninth Circuit. Okay, I get that. But bribery was not one of our legal claims against
Absolutely.
them.
Right.
All right? So that's the first false narrative that they're trying to put on the record to try and persuade the judge, he's wrong because of this case precedent. Right. The second thing is they never addressed the perjury of oath of office. So that's a big deal. They're going to lose that argument, and they know they are.
Right.
There's no precedent anywhere in this country's history that you can perjure your oath and not have
and get away with it. Right?
Exactly.
Okay. So I'm going to close out the first question. You did a great job in explaining. It's a lengthy process.
Yes.
And I think that people who, like myself, one of the people involved with this, as a plaintiff, need to, we used to say in the Midwest, hunker down for the long haul. It's going to be a cold, hard winter. And I just think that the people who are involved with this need to understand that it may take a while, but if you win this case, which I'm assuming that you will, you and your actions may change the way that all state legislatures look at this, because there are a lot of vaccine bills right now that are going to state legislatures, and even in national and Congress, they're looking at proposals and things and mandatory vaccines. There was an issue this week in a health system in Minnesota where they fired 69 people because they were not vaccinated for the flu shot. And they said, from a legal standpoint, from there, it's not in our union contract. We don't feel that it's, there are a number of reasons for it, but they got fired anyway. So now there's a huge lawsuit that's coming against this group.
There should be.
So, and I'm not going to deal too much with that because we spent a lot of time on this first question. We needed to. I want to change the narrative a little bit here to parental rights, because part of this issue right here needs to discuss when parents have a newborn infant in a hospital, what rights do they have to refuse the vitamin K shot, the Hep B shot, any other vaccines, to have the baby circumcised, or any other type of medical procedure. And they're saying Child Protective Services and a lot of these agencies are getting, police departments are getting involved now with parents at a lot of different levels, from their homes to hospitals. When you and I spoke before we went on air about the 2014 article that was published in Thrive Online that really talked about parental rights from the following case studies: Prince v. Commonwealth of Massachusetts, Wisconsin v. Yoder, Cleveland Board of Education versus LaFleur, the American College of OBGYN v. Thornburg, and Stanley versus the state of Illinois, Quillian versus Walt, Perham, etc. So you have a number of claims that have upheld the right, the inalienable right for parents to rear their children independent of medicine. And we see a lot of religious groups that say, we don't believe in this, we don't believe in this. And some have won, some have lost. But with vaccines, you're actually giving a medicine without any informed consent. You're actually giving something to a child who is well. You're not actually treating a disease here. You're ostensibly trying to prevent something that may or may not even happen in the future.
Correct.
Well, what we know about vaccines is that they're not as safe as we've been led to believe. Huge study came out last week on aluminum adjuvants and brain tissue in autopsies. There were, I think, 23 or 24 people who had given their brain tissue to science to analyze them, and one of the things the researchers did was look at the amount of aluminum adjuvants from vaccines in brain tissue, and they found in a number of these brain autopsies up to 30 times aluminum as what they compared to is what is a safe level.
Right.
Up to 30 times, which actually says it is insanity. We are dealing with an insane group of people at all levels: judicial, public health, obstetrics and gynecology, neonatal, et cetera, et cetera. So legal rights and parental rights specific to Child Protective Services, what say you?
Okay. One of the cases that we've heard about, that I've learned about this past year, was Jacobson versus Massachusetts.
Which is the 1905 law, right?
That states that the states have a right to mandate vaccines to some degree. And I finally read that case in its entirety a couple of weeks ago.
Right.
And what I learned was that one of the justices made a statement, made two comments actually. Now, it may not be binding precedent, but he made one of the comments. Here's one of the comments. He goes, there is a sphere of authority within the individual, of freedom and liberty, that supersedes any government under a free country and a constitution, that the government cannot supersede by its authority. And what that means is you have liberty under what's called your natural law rights, under your creator, of self-preservation and self-determination, that cannot be overridden and overreached by government. But if you don't know that as a citizen, you'll never even try to invoke it to think about that concept.
Right.
Now, the other thing is, you mentioned vaccines have been deemed to be unsafe in some of these court processes. I would go beyond that to say vaccines are highly dangerous because of their toxic ingredients.
Right.
Now, with respect to parents' rights in the hospital, parents have exclusive, inalienable, and natural law rights to refuse any part of the hospital service. It is a service.
Right.
It's not mandatory. None of it's mandatory.
Right.
Okay?
There's no, you can have a baby at home,
Right.
but if you're in a hospital, you can leave whenever you want.
Right. Now, when my kids were born, we had a birthing plan. We told this to doctors and nurses before we got in the hospital. There would be no vaccines of any kind, no vitamin K shots. There would be no circumcision for the boys. None of that stuff. And the kids never left my sight, ever.
Right.
Because I didn't trust them.
Right.
They said, we want to take your boy.
Which is sad, but.
Well, but I understand the system I'm dealing with. Okay, they are drones, and they will do whatever their standard medical care dictates if you let them. But I went in there with one thing in mind. I'm the superior authority over my child, not you, not the hospital, not the state.
Right.
You're not going to overrun my authority because you want to do your standard medical care and injure my child. That's never going to happen.
Right.
No, not to me. I'm too educated in the process.
Right.
And it didn't happen to them because I was like a hawk. You're not going to take the child. And thank goodness the mother's on the same page as I was on.
Right.
No, we did research on the vaccines. It's not going to happen.
Right,
So,
and you and I have spoke about this, that we had our children about the same time, give or take a couple years, and we knew our pediatrician. We told her what we wanted beforehand. I didn't necessarily watch my daughter like a hawk, but I did a little bit more when my son was born 4 years later. I held him, I kept him, none of this, but they knew in advance. So we gave them sort of a directive, almost like, end of life care or anything that you would give,
well, they have you give them a birthing plan before you enter the hospital.
Right.
So we did that.
All right, so Child Protective Services.
Okay.
I see YouTube video after YouTube video about these people banging on people, going to schools, talking to children outside of their parents' influence and saying, you need to get your vaccines, go talk to the school nurse. I'm seeing more and more of these types of things, and you and I we looked at a video recently about a man in his apartment. He said, you're not coming in my house.
Right.
So elaborate on that.
Okay, I'm going to say this again. I've said this for a couple of years now, and there are some people who have been telling me I'm too aggressive in my stance and that people aren't willing to do this. I don't care if they're not willing to do this. What needs to happen is parents are going to have to learn their rights and some process on the law. Otherwise, you're going to be a victim of the circumstance.
Right.
Now, here's what's happening. When Child Protective Services come to your door, you are not required to even talk to them about anything, about your medical care, how many vaccines you have or haven't had. That's a private issue between you and your physician.
Right.
Period. It's protected under HIPAA and the Fourth Amendment.
Right.
They can't get that unless ordered by a court. But a CPS agent is not a medical doctor or a nurse. Why are they asking about vaccines and doctor stuff?
Right.
So you need to understand this. Parents need to understand this principle. When an official from the government comes to your door or apartment and is asking you questions about anything that involves you or your child or family life, they are conducting a criminal investigation where your Fifth Amendment rights come into play, or the right to remain silent and not incriminate yourself, and your Fourth Amendment right comes into play where your right to be let alone and right of privacy.
Right.
Tell them I'll tell you what I'll do. I did this to a cop once years ago who wanted to ask me questions about a crime that occurred. And I wasn't involved in the crime, but I wanted to sharpen my talent with this guy. It was 3 of them. And I said to him, officer, I will talk to you under one condition, that you sign a waiver of immunity statement, that if you lie about anything I tell you in your report or misconstrue the facts in 1 centimeter, that you consider to be sued under RICO and the civil rights statutes for violating my rights and committing a false police report. Because I'm not going to do that. Then I'm not going to talk to you.
Right.
I'm not required to talk to a police officer ever. I don't care what the conditions are.
And a lot of people, don't understand that. I don't want to get into police here. I want to stay with Child Protective Services, but they're almost the same playbook.
Yes, but it goes to Child Protective Services. You're not required to talk to them, but if you're going to talk to them, and I enjoy jousting with them because I'm going to tell them 1 or 2 things. One, I'm recording the conversation right now. You're being recorded for civil rights purposes. I'm not bashed and shy about that.
Right.
And whatever you say will be used against you in the higher court of law. Now, you have a warrant to see my house and my child, signed by a judge in blue ink. If you have no warrant of probable cause to enter my premises, to look at my place, you're not getting into my place.
Right.
Period. I don't care how many cops you have in tow. It's not going to happen. And parents are going to have to learn this process. or they're going to be a victim of the circumstance, collateral damage, because the system doesn't care
Right.
about your
Yeah,
legal.
and I really think that. Now, we are going to have your email
Okay.
on the screen. So I want people to, if they have questions about Child Protective Services, parental rights, etc., to send you a direct email, and you can converse with them, one-on-one if you need to. And hopefully, many people will start talking with you about this. Because my next question is more of a comment and a question. You've made quite a name for yourself here in the past year and a half. You've done a number of podcasts. You've been interviewed by some local, regional, and even national radio shows. You have presented at some rallies down in the Los Angeles area, and you will be presenting in 2018 at the Autism One conference. So tell us a little bit about that, because I'm gonna end with the last question after that. So.
Well, I don't. With respect to the Autism conference, it's coming up in May of next year.
Right.
I don't know what my role is going to be yet. I know they've invited me out, so it hasn't been disclosed to me what they want from me in terms of what I can contribute to the conference or to the speaking engagement. Mm-hmm. I have no idea. Perhaps it's my wisdom about the legal construct and how to perhaps how the parents should posture themselves with respect to the Child Protective Services, right, or any kind of adult vaccine mandate coming down the pike.
Right.
I don't know yet, but I have some good things to tell them about the doctors' licenses and what the doctors can do to protect themselves from the government trying to pull their license from doing that which is ethical for their clients. Mm-hmm.
All right, so last question with the minute and a half we have left. What details would you share with the vaccine, I call it the vaccine freedom community, in the next 12 months that you think are going to be the most important for them to uphold their rights?
Ask that question again.
In the next year, what do you think are going to be the most important things that people who are in favor of vaccine freedom, freedom of choice, mm-hmm, what are the big things? And I think one of the things that I see is, a lot of these types of things. Well, I hear the music, so we'll grab that in our next episode. Okay. But it's tell us your email address.
Email is Travis_M_93101 at yahoo.com.
Yahoo.com. And again, one of the country's top minds, in my opinion, in the whole issue of RICO lawsuits. So I'm going to have you on again. You're going to probably be one of my regular guests, and we're going to really dive into this issue so everyone understands every single aspect of it. So for this issue of Med Health Fit with our guest, Travis Middleton, this is Eric Durack. Thanks for watching. We'll see you next time.